A person gets injured, let's say it's at a condo unit. Let's say they're a tenant or they're a resident, they're an owner of a condo, and they get injured in a common area. Here's what often happens. They come to see me and almost immediately they have something with them, a letter denying responsibility by everyone. When I take the case, I'm mindful of a few things I know about this sort of case. The first thing is the HOA is generally responsible for the common area. The second thing is almost always the HOA will shirk that responsibility by hiring a management company. And the management company is going to be responsible to handle all of the day-to-day responsibilities of that condo unit. The management company, in turn, hires snow removal, lawn care, maintenance folks. The important thing to understand once you have an understanding of that is by the time the client comes to see me, there's already been this general denial of any responsibility. However, when you scratch the surface and do what we call discovery, during the litigation phase of a case, when I file a lawsuit against all of these entities and start requesting that they provide for me the internal documentation, the letters the HOA sent originally to the management company saying, hey, looks like you're at fault here. The letter from the management company, or several letters, to the snow removal company says, you know, it looks to us like you allowed snow to build up, which created the dangerous circumstance. When you have each company then responding with their own investigation, what you end up realizing once you've captured all of this information is there was probably a great deal of infighting, and there still may be a great deal of infighting between these entities, each trying to point the blame to somebody else. One of the things that I think is critically important is the discovery, the investigation we do of a claim like that. And here's why. When the HOA gets notice of the injury, almost always there'll be some communication. I'm, in fact, surprised when there isn't, but there nearly always is communication. Either it's an email form or a letter, where the HOA sends a letter to the management company saying, hey, we want to know what happened, or you're responsible for the injuries caused to our tenant, caused to our owner. It's only when you bring the lawsuit that you will see the unified front of them all saying that you caused this yourself. But when you scratch the surface through discovery and you find out that their own investigation yielded responsibility this way or that way, and that probably nobody at that point was really blaming you at all, you end up learning how to properly pursue these claims. Simple fact of the matter is, generally, these sorts of claims are winnable claims. But if you don't do your homework, if you don't roll up your sleeves, if you don't make the requests, if you don't demand the documents, if you don't take the depositions, if you don't learn about those early investigations, then the lawyer that you've allowed to handle this case is missing out on a major opportunity to learn a whole lot more than that unified veneer that they have when they come to court. And when you can show them to be hypocrites, when you can show that they're taking a different position in court than they took when they were investigating their own claim, that's a recipe for either a major jury verdict or an incredible settlement.